Hi everyone, my name is Dammy Aromiwura. I'm a mortgage broker. I'm here with Fikemi. Hi Fikemi.
Hi everyone, my name is Olufikemi Aideloje. I am a lawyer licensed to practice here in Ontario, Canada. My areas of practice are in real estate, wills and estate, family law, and immigration law. Thanks for having me.
Thank you so much for being here, Fikemi. Lately, there's been a lot of conversation around pre-construction properties. We've also seen a lot of deals go south. So I thought this would be a good discussion to have. I posted a reel recently about pre-construction, and there were a lot of comments. And so I thought, okay, we better speak to the lawyer. So thank you. I'm excited for us to have this conversation. Before we go on, we need a little bit of a disclaimer. This video is for educational purposes only. It's not legal or financial advice for your specific situation. Always consult a qualified professional before making decisions for your purchase or finances.
Thank you. Thank you. And to echo the disclaimer again, this is not legal advice of any sort. If you have a specific matter going on, it's better you actually reach out to a lawyer, and also you can reach out to us if you think that you need additional advice or something that is tailored to your own particular experience. Thank you.
So let's say that a client purchased the property, at closing the value has dropped. What would be the next step?
First of all, your lawyer has to reach out to the builder's lawyer. There are several options on the table. One is, as everybody has been echoing, to walk away, but it's not necessarily the best option. There's something called a mutual release, where you would negotiate with the seller's lawyer or the builder's lawyer to pretty much agree that, yes, I am in default, but I am releasing my either a portion off or the entirety of my deposit so that I can be let go. And then there's the other option where you actually go to court to fight it out to see if your deposit can be returned or not. Sometimes too, we seek extension because sometimes the problem might be with getting additional financing. So we would seek an extension, and those most of the time comes with additional fees. So extension fees, additional legal fees per DM, and those sort of things. So there are options, but then it's based on looking at your own financial stability at the time and which one works best for you. So these are things that you will discuss with your lawyer.
So the first step is let's figure it out. Can we reach out to the builder? Can we negotiate? Okay. Okay. So my next question on Instagram, I would say 50% of the comments were like, walk away. What does that mean when someone chooses to walk away from a purchase contract that they have, in this case with the
So
builder?
when you enter into an agreement, it is legally binding. So the term or the phrase walk away that people are saying, I guess, is ill-informed, because people think that's the only thing you have to lose. You already have your deposit. You can just walk away and then that's it. But sometimes that's not the best way, because you remain in default and the builder's lawyer can come at you from a legal perspective. And what does that look like? It is maybe you purchased the house for 700,000 and you put a deposit of 50,000 down. People are saying walk away from the 50,000. First of all, you saved up God knows how long for you to make that 50,000, so it doesn't make financial sense to walk away. Second of all, even if you walk away, they can come at you to recover the difference, because, for example, as we're saying, the value has dropped. It used to be 700,000, it's now 600,000. You only put down 50,000. In that case, if you walk away, they still have not recuperated the loss. So they will take you to court to come at you for the remainder of the 50,000, as well as any legal fees and expenses or cost of advertisement. So it does not necessarily help you to walk away, but negotiate a mutual release might be better for you.
Okay. And what does a mutual release mean for people that don't know what that means?
So to just put in the layman term, as I said earlier, an agreement is legally binding. You agreed to something, so it is binding. You are bound to do that. So because of any reason, either the value dropped, you lost your job, whatever it is, you are not able to complete that contract. Now you are going back to that person and saying, please, this is my situation. I'm not able to, carry out my end of this bargain. Can you please let us agree to release each other from this contract? And when you agree on that, what that means is there has to be something. You can't just say, well, can you let me off the hook? There has to be something coming from your end. And most of the time is you leaving your deposit either partially or in full. So that way the contract is cancelled and you're not in default. Everybody goes home happy. So it's like a win-win situation.
Thank you so much for that answer and the clarification. I think at this point, so essentially, someone in that situation, you've tried financing, that didn't work. Fikemi has helped you try to negotiate with the builder, that didn't work. You've decided to walk away, and then people say, "See you in court." What does it really mean? What are the implications of "see you in court" in quotes? Because that was actually a very popular comment as well.
A lot of people always say see you in court. That's because a lot of people think that when you go to court, the court automatically grants you what you want. And what you want in this system, meaning that your refund will be given back to you, or your deposit will be refunded back to you. Now, remember, as I said earlier, a contract is a contract. You signed and then you put a down payment down that shows that you are going and you're willing and you're able to complete that contract. Now, most of these people, they are very sophisticated, the builders, they're sophisticated. So the terms in their agreement are always very sound. So a lot of times it is difficult for people to get out on those technicalities because most of the time there's no technicalities. These are big people that have been in business for years and they have perfected the terms in their agreement. So a lot of times, even when you go to court, you might still not end up, getting your deposit back. And you might have to, at that point, not only lose out, but also pay the legal fees and damages to the builders. So it is very important that you understand that going to court does not necessarily give you any kind of remedy. Let me give you an example. So if you decide, you know what, I've tried to seek for vendor take back, you didn't answer. I've tried to ask that you abate the fees because, of course, the value of the property has dropped. So you should understand, just reduce 100,000. They've refused. You've tried to get financing, that's not working. And then you say, you know what, I'm going to see you in court. When you get to court, first of all, court process is a very long process. A lot of times you could be there for years, not 1, not 2 years. So that already is wasting your precious time. Second of all is you have to pay a lawyer. That's in tens of thousands because we are now talking about litigation. Because in litigation, lawyers will charge you an hourly rate. So again, that's on top of what you have already lost. So most of the time, it is not necessarily the best outcome. But if you then go ahead and you fail or you not fail and you lose that matter, then you will be paying cost of the of the builder's litigation as well as any other damages that has been assigned to you. So a lot of times saying see you in court does not help you. And that takes us back to the mutual release where we are discussing how to, let this contract die an easy death and it's a win-win for everyone. And in that case, something's got to give. It might be the deposit that you have in entirety or partially. So I think just saying see you in court does not help you. It's looking for a lawyer that can actually advocate for you and get you that mutual release so that you are fine afterwards.
Yeah. Or even if you say see you in court, that means that you're spending a lot more money to even get
A
an
lot.
outcome that might not actually be favorable, right? To you.
Exactly.
Yeah. Based on
And
cases that you've seen, where do you see the law tilts? Do you think that a lot of buyers are getting off, or do you feel like the builders are getting their money back?
I think it's a seller's market here in Ontario, especially for the builders. As I said, these are companies that have perfected their craft. They have perfected the terms of their contract. So most of the time, when you sign this contract, you're pretty much, quote and unquote, signing your soul to the devil because they know that the law backs them up. They know that for wherever you want to come from, they have a term in the agreement that shows that they have informed you ahead of time that this was going to be the ending result. And this is what takes us to making sure that before you sign any contract, get your lawyer to review because at the beginning, you can make sure you negotiate favorable terms for yourself. Otherwise, you are stuck in that particular agreement of purchase and sale. So to answer your question, most of the time, from experience, I think the builders get the upper hand in this market
Mm.
right now.
Okay. Yeah, you've already touched on my next question, which is how can we prevent the situation? Let's say I'm looking to buy a new build. how would you approach? What would you suggest that I do?
So buying a new build, it's for a lot of people, at least before the pandemic, it was a very lucrative thing to do, especially people that want to get into the real estate business, because most of the time you get it cheaper and it appreciates in value. Unfortunately, because of the overshooting of the purchase price in the last few years, it's the decline has been the case recently. So most people have been losing hundreds of thousands. The property that was worth 1.2 million is now only 900,000. So you might not necessarily have something to do to prevent the value from dropping, but at least you might have some other alternatives that help you to be able to not necessarily get off, but pass on the contract to somebody else. So as I said, first thing first, if you're looking to buy a new build, review your agreement. There's a 10-day cooling off period. Take it to your lawyer. Your lawyer might not catch every single thing, but at least they can put some terms that are common that we see based on our practice. One of it being extension.
Hmm.
Does that document allow you to extend in the case that there's a financing issue? Are you able to seek extension? And what will that extension cost? Some of them would have put a cap of admin fee of 1,000, admin fee of 1,500, right? So is that present in the agreement? Another thing would then be, are you able to assign your rights in that property? For some people, they don't even have any intention to close the deal anyway. They just wanted to appreciate so that they can then sell it off to somebody else. So
Yeah.
we always make sure that we negotiate that into the agreement. So in the case where there's a problem, you are able to, sell it off, pretty much assign it to another purchaser that is interested and willing to buy. And I think the next one is also the language in the document is very important. Some people will say for you to do transfer title or for you to assign, you must seek the consent of the builders. And they put arbitrarily that they have the right to arbitrarily decline. That means they
Hmm.
can choose not to. So most of the time we look at that and say, you know what, negotiate with the builders to change it to it cannot be unreasonable, consent cannot be unreasonably withheld, which means for them to decline, they have to provide a reasonable excuse. So there could be a lot of things that lawyers would have caught when they go through your documents to ensure that you have that protection. Some people will also have vendor take back. And that one, I can't explain the full vendor take. I think that's something that Dammy, if you want to know what a vendor take back mortgage is, you can ask from Dammy afterwards. They will be able to give you the opportunity that, okay, you're not able to get financing, but we as the builders can provide financing. And if you're unable to then pay, we can take back the property. So it's like you're using it as a security for the money you're getting. So there's a lot of things that you can do actually that will protect you in the long run.
Okay, thank you. As you're talking, just popped in. Are there clauses that you can use to prevent situations where, yes, I purchased the property, but if in 3 years' time my appraisal falls short, are there clauses like that? And are
No,
the builders willing to accept
no, none that I know of, because no reasonable businessman will
that?
put that, because
Yeah.
these are things, it's real estate.
Exactly.
Everybody knows that it could go up, it could go down. So you're taking a risk by purchasing a
Yeah.
pre-construction. So knowing that there's no builder that will allow you to include that clause where if the value of the property drops,
Mm.
then I can walk away. The same way where, think about it from this way. When you purchase, maybe the value was 600. They too cannot put a clause that if the value appreciates at the time of closing, then we're going to recover the difference. So
Yeah.
it works both ways. It's a two-edged sword.
Yeah.
So I don't believe any
Reason-
right thinking businessman will allow you to put such clauses.
Okay. Which is interesting, and one of the reasons I personally love resale. I've seen some purchase agreements where there's a clause that you could say that if, for example, I bought a property and the appraisal doesn't go through, the deal can essentially fall apart. But I've not seen that in new construction.
Yes. For new construction, because it takes years most of the time to
Yeah, that's
complete.
true.
So that's a risky thing to do. But with a resale, you know what you are getting. And
Yes.
most of the time, too, you can't leave it in perpetuity, right? It's not just a blanket
Hmm.
till eternity. You put
Yeah.
a financing condition, it's probably 5 days,
Yeah.
1 week at the most. So you go do your appraisal, make sure that everything is as is, and then you can then do a notice of fulfillment and you proceed. but it's not left forever that, okay, maybe after I finish purchasing, or maybe we're going to close in 3 months. If a day before closing, I find out that the value is not that high, I can come back. There's always a time frame for you to do all your findings because it is a real estate property. With new build, you don't get such, apart from that 10-day cooling off period, where within that time, you can also get an appraiser to say, is this actually what, if houses in this area, is it worth that amount? Because they're asking me for 1.2, and then your appraiser can say no. And in that area, it's probably 900, or there's a possibility of it dipping further. So that gives you that informed consent before you proceed, right? Informed information before you proceed.
Yeah, that's actually a very good point because yes, we are saying, oh, pre-construction fell in value, but a lot of these properties at the time of purchase, that property was never worth that amount because they were banking on future appreciation that was never realized. So it's a good point
Yes,
that even with pre-construction, you should still be doing some level of due diligence to see what's the today's value, so that you know how much of
absolutely.
that price is actually projected price versus today's price. Okay. Okay, thank you so much for sharing this insight. I've learned a lot. I'm sure that all the people that had questions, hopefully you've learned a lot as well. If you have any questions about your mortgage or financing, if you have any pre-construction coming up, please feel free to reach out to me. And if you have any real estate questions, any purchases coming up and you need a reliable, trustworthy lawyer, please reach out to Fikemi. Any word to add here?
Yes, absolutely. So if you have any, as she has, as the Dammy has mentioned, if you want to reach out to us, you can get us at our email address, info@fikemislaw.com, or you can message us or send us a text or WhatsApp, or even give us a call on 647-228-1130. And just to round up, so know that when the value of your property drops, there are options for you. One could be abatement, where we're negotiating with the builders to reduce the amount to, if not to the current amount, but at least something close.
Okay.
We have the opportunity for you to assign that, but this must be done way before the closing date. We have the opportunity for you to seek for an extension so that you can find alternative funding. You also have that opportunity to seek if they can give you a vendor take back mortgage. If all of this fails, then your next best thing would be to ask for a mutual release.
Yes.
Court might be great for some people, but for some people they can't afford the legal fees. So think well, speak to your legal advisor before you choose the next step. Thank you.
Thank you very much. If you've enjoyed this video, if you've learned anything, please give us a like, share it with your friends and family so that they can learn something and would hopefully we'll come back and talk about another aspect of mortgages and property financing and deal 9 yards. Thank you, everyone.